Hey everyone, I'm Joe Miller. I'm Vice Chair of AHLA's Antitrust Practice Group. I'm also co-chair of Mintz Levin's Antitrust Practice, where I focus in the healthcare industry. I'm here today with my partner, Bruce Sokler. Bruce, will you want to introduce yourself for a minute, and then we'll get
Sure.
going with the conversation?
Hi, everyone. As Joe says, I'm Bruce Sokler. I'm the other co-chair of Mintz's antitrust practice, and I've been doing healthcare antitrust for several decades, I'm afraid to say. Joe, it's a rare event when antitrust leads the news in the New York Times, and that seems to be happening more and more frequently. Very recently, it happened in connection with the executive order President Biden put out on July 9th, which called for an across the government focus on antitrust competition issues and identified 72 initiatives uh, across several industries. Um, what do you think is of particular importance to the healthcare industry in there?
So there's a lot that's of importance to the healthcare industry. As you said, it cuts across industries, and it's got a particular focus on a few industries. Healthcare is one of them. Of course, the FTC and the Justice Department has been focused on healthcare for a long time. But I think here they're particularly looking at hospital mergers. They're encouraging the FTC to go back and examine what they've been doing and to, particularly focus resources there on pharmaceutical issues and pharmaceutical distribution and PBM issues. So those are three of the most important topic areas and industries that the administration thinks they'd like to focus on.
Yeah, and one other thing I noticed that's probably particularly relevant to the healthcare industry, even though it was expressed as a more general set of initiatives, is in sort of in the labor wage area. Uh, the executive order has this recommendation that the FTC consider banning unreasonable non-compete provisions in employment agreements, et cetera. And we know that there's been litigation over non-competes and no poach agreements in lots of industries, including uh, the healthcare industry. Moreover, the executive order puts some focus on uh, wage and salary and other surveys that are done by employers, and calls on the Justice Department and the FTC to take a harder look at guidance they already have in place against that, and also suggests that some of this stuff should be uh, also transparent to employees, to workers, which is, I think, consistent to with the Biden administration's pro-labor approach on a lot of things. And while it's like in a different section of the EO than healthcare, it's one that people ought to pay attention to.
Absolutely. So there was, in the previous administration, focus on labor issues of sort. I think there's a more aggressive posture here. So over the last year or so, you saw some state AGs going after non-compete provisions in low-wage industries, where I think it's, from an antitrust perspective, easiest as a plaintiff to focus. Here, I think there's a broader focus on non-compete agreements. The no poach agreements, meaning I agree not to poach your workers, you agree not to poach mine. That in 2016 was a huge focus of the administration and announced, and it's actually still on DOJ's website, that would be criminally prosecuted. So, if they caught you from here on out, that would be the focus of a grand jury investigation, and those have actually happened. So I think you see, even more of a focus, but this has not been ignored. I think it's important for healthcare because traditionally, or not traditionally, but some of these cases that you have seen in the past have focused on healthcare. So there was a, a nurse nurse wage case and class actions probably 15, 20 years ago. another one from the Justice Department in the mid-2000s for traveling nurses, where there was agreements among hospitals to suppress their wages. Those were civil cases, and I think you need to bear down a lot on that now. I think that's common for hospitals to have wage surveys for all sorts of employees to share that information. That's something that everybody should pay attention to. And of course, on the no poach front, there was a famous case in North Carolina involving Duke University that entered into a no poach agreement with a rival hospital that got them into some trouble, and there's more litigation over that. So I do think that's it has been a focus. It'll be an increasing focus. I thought it was interesting in the executive order encouraging Justice Department to go back and review their 2016 policy, which had been a more aggressive stance than you'd seen in the past.
Your reference to the word encouraging or encouraged is particularly appropriate because the executive order, for the most part, is not self-executing. And in fact, the president really doesn't have the authority to implement many of the things, particularly things that would have to be done by independent agencies like the Federal Trade Commission, Federal Communications, and others. It didn't take long, however, for the chair of the FTC and the interim head of the Department of Justice to put out a statement the same day last week to the effect that we hear you and we're going to start a review of the merger guidelines to toughen them up.
So on that in particular, I'm sorry to interrupt, but I think that's an important point to bring out. So the merger guidelines, of course, cut across every industry. And this kind of got buried in the news with the executive order because it encompassed so much. So if FTC and DOJ do nothing else besides toss the current merger guidelines and do something much more expansive, that's going to be a huge deal. It will take them a while, I think, to write it. But there's a big gap between case law and what the agencies actually do. That is, the case law is more permissive than the agencies, than the agencies bring their cases. They can bring them, they cite cases that go back several decades that are no longer sort of forward-looking antitrust analysis, because they're actual precedent, and that's what a district court has to follow. But the analysis that they do internally and to decide to what cases to bring is more along the lines of the merger guidelines. And so this is a pretty big deal.
And it should be looked at alongside of, I think, other activities that are happening in the antitrust area, both on Capitol Hill, where people probably know that there's a dozen or so bills kicking around. Whether any of them will get through this Congress or not is a different question, but they range from process to giving more money to the agencies to changing the substantive standards. But particularly, again, for the healthcare industry, the new chair appointed by Biden of the FTC, Lina Khan, has hit the ground running. And she had her first open meeting, and she took several steps. One was to withdraw a policy statement that made it clear that the FTC Act Section 5 prohibition of unfair method of competition was going to be safely grounded in the Sherman Act and in the notion of consumer welfare, and basically opening it up for a broader application, at least at the commission level. Moreover, the commission, by a 3-2 party line vote, authorized 10 years worth of investigations, potentially in 7 focus areas, one of which, of course, is hospitals and previously, even before she arrived, the commission announced some retrospective looks at provider mergers among physicians and non-hospitals. So there's a lot going on. And before we run out of time, we ought to go back to the EEO, I think. And Joe, it'd be helpful if you mention some of the recommendations or encouragement that was done in the pharma and pay for delay area.
So that's another important area, and this is also news. So among the encouragements was for the FTC to use its rulemaking authority to tackle some of the sticky pharma issues, pay for delay or reverse payment in particular. And so this has been something the FTC has been, pursuing for decades. It finally got a case to the Supreme Court, the activist case. They won that at the Supreme Court. They, found a standard to apply, and now they've applied it. And then there's, recent, as of a couple of months ago, Court of Appeals decision out of the Fifth Circuit applying the rule of reason, and so that has, taken a long time to work its way through. And I think, one of the reasons is that it's an enormously complex set of issues that comes out of, how to settle intellectual property disputes when there's market power involved. As there is frequently with pharmaceutical products. Here, the encouragement is to write more general rules using the rulemaking authority. The reason that this is novel is that it's never been done, as far as I know, for competition issues, only for consumer protection issues. And so taking a more broad rule-based approach as opposed to a case-by-case approach will be, new for all of us. Question whether the FTC has the authority to do that. I'm sure that'll be challenged if in fact they go forward with that. So a little more news out of the EO on that front.
Right. Here's my final observation, and then Joe, you can back clean up. The executive order also established a council within the White House to coordinate all of these activity and to keep track of the 72 initiatives. It's unclear sitting here in July of 2021 at the end of the day how much is really going to change. However, there's going to be a lot of pulling and tugging here on these issues throughout the government. And I think what the executive order and these early initiatives that the FTC make clear is that they mean it. They're going to try, and things are going to happen, and it's going to lead to uncertainty and potential change. And people are well advised to keep close and not just view it as more noise, coming out of our nation's capital.
Right. No, I completely agree with that. A lot of it, some of it will be noise. Some of it's going to be relatively easy to do. Some of it's harder to do. So I think there's, bipartisan consensus on some of the recommendations. For instance, lowering barriers to entry for some jobs. Hair braiding has been a common one. There's been a bunch of cases against dental boards to try to get non-licensed dentists to be able to do some dental services, things like that. I think that's relatively popular across the board, except if you happen to be a dentist and don't want the competition. Other things will be much harder, but I do agree that Lena Khan in particular seems quite energetic and seems to take a different approach to her job at the FTC, which has traditionally been a consensus, a place that's run through consensus. When Tim Uris came in as George Bush's FTC chair, he had a goal to have unanimous votes all the time. And traditionally, being a Republican or being a Democrat as a commissioner didn't really matter that much, except for you can't have more than 3 of one party. Here, this seems much different. It seems that she's willing to come in and do things on a straight party line vote, and is quite eager to do so. So I think that's another cultural shift.
So we've only scratched the surface, but hopefully anyone who listens or watches this will find it helpful and maybe whet their appetite to dig deeper and keep track of this stuff as it evolves.
Thanks, Bruce. And thanks to the AHLA for hosting us. For those who are interested, the AHLA will host a 90-minute webinar at the end of August, maybe August 18th, 19th are the dates we're looking at, to dive deeper into these issues. We'll get some different perspectives, different voices, and we hope you'll join us there. Thanks.